Good morning friends, Sat Sri Akal, Adab. This is once again in the same series of my documentations and sale purchase. We have to understand what does Rule 10 say. It very clearly reads in CLA that TP Act was applicable. Now I'll just talk of Punjab. You'll be surprised that TP Act was never applicable in Punjab as per various notifications. Because this part of the territory was never a British territory. So, 1924, where under section 287 of the Cantonment Act, the same act was being applicable. What does that definition speak? We can also see the Governor General Orders of 1798, which allowed sale and purchase. So there are so many things which we can go into. We can go into the definition of immovable property, the word used under TP Act or General Clauses Act. So we need to really work on this, that these sale deeds which were being made, under what provision were they being made? Because if we read the GGO, it clearly says that no sale could be done without permission. So the word sale could be done. Now whether that sale was under some registration act or some TPA act or any of the Governor General orders has to be seen. Now TPA Act was notified on 1st July and it was extended to the whole of British territory except to those states which were part of Part B states, or more specifically Bombay, Punjab and Delhi, till November 1956, that the applicability of the TPA Act 1882 was made applicable in all those territories which were directly governed by the Governor General of India or through Governor or any other office under the Governor General in Council. So thus, at the time of the commencement of 1882 TPA Act was enforceable in all the territories in India under the British rule except Burma, Bombay and Punjab, then Pepsu or Satluj state. Bombay was effected on 1st January 1893, province of Sindh on 1st January 1915 and in Burma 22nd December 1924. Similarly, the act was notified for Manipur, Pant and Pipaloda in 1929. After India got independence in 1947, native states were merged or in jurisdiction was handed over to the provincial government. Under the Extra Provincial Jurisdiction Act 1947, the power was extended. The Merged States Law Act 1950 and Part B states were brought under the same act. Now the expression except the territories which comprised of Part B states was substituted for the expression except Part B state. These changes were important for the former native states called Part B states, which had already been included in the Republic of India. This was extended to Tripura, Vindhya Pradesh, now which is called Madhya Pradesh, on 16th April 1950. Kerala, it was extended by an act of 1955. Mysore except Bellary under Mysore Act 32 of 1951 and Rajasthan official notification of 1952. So now somewhere our advocates and the people sitting in these cantonments would try and gauge whether TP Act 1882 was applicable in your part, which were Part B states. But this act yet could not be made applicable in Punjab. In Punjab, it regulated by the rules of equity, justice and good equity. Even this act is not applicable, yet courts normally follow the provisions. There is a judgment under Lahore of 1947, similarly of 1955 Punjab AIR. It must be understood that section 54, 107 and 123 have been extended from 6th May 1935 to to all municipalities in Punjab and to all notified areas declared and notified under section 241 of Punjab Municipal Act 1911. So, in Punjab, we say TP Act was not applicable, but we say these particular sections which were mentioned in Rule 10 were notified under the Punjab municipalities. So, was Ambala a municipality or Jalandhar, which were in Punjab at that time? Firozpur for that reason, Dakshai, Kasauli, Sabatu. So, section 54, para 2, 359, 107 and 123, which were added by an act of 1885, retrospectively to sections these 54, 59 and 107 and 123, under a section of 287 of the Cantonment Act 1924. So, notwithstanding anything in the foregoing part of this section, 54, para 2, 3, 59, 107 shall not extend or be extended to any district or tract of the country for the time being, excluded from the operations of the Indian Registration Act, section 2 of the 1877. 1902, which further came on to under the powers conferred by the first section of the Act. This would mean if the TPA Act is not applicable in any part of the state territories, it does not mean that the sale transfer of property, leases or mortgage gifts would take place in Indian Registration Act. So, we need to again understand why the Britishers were jumbling or were trying to make a puzzle of these acts. Sales were allowed, gifts were allowed, mortgage of cantonment properties were allowed under the TPA Act. So, which of the statutes? The 4 statutes dealing with the issue with users, fraudulent transfer and clandestine mortgage are repealed by an act of 1842 of the Governor General in Council. So, the remaining part of that act, which further became the TP Act by the Bengal Regulation 1 of 1798 and Bengal Regulation 17 of 1806, they've been totally repealed. There was another regulation under the same sale and purchase of 5 of 1827. One of its section was repealed. The Punjab Law Act 1872, Awadh Law Act of 1876. So, they all were incorporated, and we really need to understand all this. Now, if we cannot understand this and our advocates cannot be made to read about this, it becomes difficult to prove whether your sale or your sale deed was a registered document minus the Grant Act, because if we go by the Crown's Grant Act, there can be no TP Act applicable. So, friends, we need to understand this, and we have to make our judiciary, advocates, by itself our department understand all this. Because once we are educated, only then we can make somebody else educated. Thank you. Good day.